Hey everyone, Attorney Jason Cromey here with another session of the law in a way that people can understand it. Topic today is going to be, can I get that DUI case of mine expunged? The answer is going to be, it depends, like it is with everything. So the general rule, if you are convicted of DUI, meaning you entered a plea to DUI or you went to trial and were found guilty of DUI, by law you were going to have to be adjudicated guilty, meaning formally convicted of the crime. So what does that mean in terms of expungement? What that means is that the answer is probably no. If you're adjudicated guilty of an offense arising from or coming out of an arrest, then that arrest is barred from expungement under Florida law. Similarly, if you've ever been convicted of any other crime, no matter how small, no valid driver's license, attaching a tag not assigned, even if it's 5 years ago, that would bar you from ever getting an expungement. So an adjudication of guilt, a formal conviction, will bar an expungement. And in DUI situations, because the statute requires mandatory adjudication, you're not going to be able to expunge it if you pled guilty to DUI or you were found guilty at trial of DUI. So what are exceptions to that rule? Well, there's really no exception to the adjudication part, but let's say that your case was dropped, right? So if your case was dropped, your DUI charge was thrown out, and you have no other prior record, then the answer in that situation is going to be yes, you can get it expunged. Now, when I say thrown out, I don't mean reduced down to a reckless, or we'll talk about that in a second. I don't mean a withhold of adjudication on some other charge. I mean like the state null proster, it was dismissed. So if it goes away, and you have no other prior criminal convictions, then you will be eligible to expunge that DUI arrest. And what does that mean? That means that it's going to take down your booking photo from the sheriff's website. The case is going to come off the clerk's office website. And if someone were to run, like if you were to apply for an apartment or for a job at a civilian agency, then in that situation, it wouldn't show up on your criminal background check. So it's a great thing. So again, we've got, if you're adjudicated guilty, meaning convicted of DUI after a plea or a trial, you're not going to be eligible for expungement. If your DUI case was dismissed or dropped and you have no other criminal convictions anywhere in the country ever, then you'll be eligible to have that DUI conviction expunged. So what would be the third possibility is a situation where perhaps you get a reckless driving reduction. You know, they take your DUI, knock it down to a reckless driving, and agree to give you a withhold of adjudication. A withhold of adjudication is a unique thing that Florida's got. The federal government doesn't have it. Some other states may, but it's like being convicted, but not formally or really technically convicted. It's a strange hybrid thing. So it's like the judge finds you guilty, but doesn't really say it out loud. So in that scenario, let's say your charge gets reduced down to reckless driving and the state agrees to give you a withhold of adjudication, maybe some probation. Then you'll be eligible once your probation is over, and assuming you've got no other criminal convictions for anything ever, anywhere, you'll be eligible to have that record sealed for a period of 10 years. Sealed essentially means that no one can go snooping around inside your court file. All right. It's not quite expungement. It's like halfway there. And if you've had your record sealed then for a period of 10 years, then after that 10 years is up, you'll be eligible for expungement of the record, meaning poof, it goes away. So long as, again, you haven't been convicted of anything anywhere in the world or in the country. But anyways, those are your typical three scenarios. I've been adjudicated guilty on a DUI, meaning I went to trial or pled out, and by law, I had to be formally convicted. In that scenario, no expungement. My case was dropped. My DUI case was thrown out of court. I have no prior criminal history. And the answer is going to be to you, yes, you're eligible to have that thing expunged. And then we've got the third typical situation, which is, well, my DUI was reduced down to reckless driving. I got a withhold of adjudication and put on probation. If that is your situation and no prior criminal history, then you're going to be eligible to have that record sealed, and then after 10 years have it expunged. So we are more than happy to talk to you guys about that, whether or not you're eligible for it. It can be a little tricky, a little complicated to figure out exactly what situation you're in, but we're more than happy to pull your case up, give it a quick look around, see what's going on. So give us a call at the office to find out whether or not your DUI arrest is eligible for sealing, expunging, or both. All right. Thanks. Talk to you soon.